All rise. The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. You may be seated. Good morning again. We have one case on the docket today. It is Ninja Academy Incorporated doing business as Champions United versus the Department of Agriculture and Consumer Services. Counsel for the appellant, you may proceed when you're ready.
Thank you. George Levesque on behalf of Ninja Academy, doing business as Champions Unite. I'd like to reserve 5 minutes for rebuttal, if I may.
So noted.
First, in response to this court's order entered yesterday, I'll go ahead and address those issues. And what I'd like to do is kind of discuss each question from the court in turn. And the first question dealt with whether 120.68 governs the appellate proceedings, and specifically the effect that the limitations set out in subsection 4 related to the record transmitted by the agency clerk. It's our position that the reference to record in 120.68 is probably a broader reference than that contained in Florida's appellate rules. We believe that the record there would refer to this court's record as contemplated under all of the appellate rules. When you look at 120.68 paren 5, it references the record that would be provided according to the appellate rules. 9.190C4 brings into that equation the idea that for some administrative challenges that are not conducted pursuant to the APA, that those will be, the record will be generated based upon the appendix filed by the parties. The second question, and again, this is sort of one of those areas where it's a unique feature of the department's procedural rules, but the second question asked whether this is a review of administrative action not governed by the Administrative Procedures Act, and we believe it is. Now, to be clear, the department's appeal process exempts them from the process of 120. It doesn't exempt them entirely from the application of 120. In their appellate, or their appeal rule, which it's a rule under the Constitution, it has to be a general law that vests this court with jurisdiction. Their appeal rule references, and you've got to go through the different cross-references, references the authority to pursue an appeal under general law, and we believe that is in reference to 120.68 paren 1. So,
well, but how can a procedural rule give us, procedural rule, be it the appellate rules or be it an administrative rule, give us jurisdiction or authority to review administrative action? How can that count as general law?
Because I think if you look at 120.68 paren 1, it provides review for all final agency action. Final agency action is not defined anywhere in the statutes, or at least that I was able to find. Final order is, and it references a subset of what final agency action might be under certain procedural or certain processes that are spelled out in statute 120.569, 0.57. But final agency action, we believe, is a much broader term that would apply to a broader set of actions other than just what is spelled out in 569 and the disputed hearings of fact and no disputed hearings of fact that are set forth in 120.57 in the subsequent statutes there.
But, I'm sorry, go ahead.
No, please.
Then in the procedural rule 9.190 sub 3 or B3, what type of agency action would it be referring to? So that is the, action not subject to the Administrative Procedure Act. Because I understood your earlier response to be basically all of that would be covered under final agency action.
Well, there are other types of agency actions. For example, some local government agency actions are going to be subject to 120. Some are completely outside of that scope. Certainly to the extent that we're talking about like a zoning ordinance that doesn't have the same 120 provisions apply, those would be covered here because those entities are not covered under 120. That would be the type of, I think, government action that we're talking about here. Where we're talking about the department's rule, through a series of cross-references, references the authority that would be vested in the statutes. And again, it's not the rule that's vesting the authority, it's the statute, 120.68 with the final agency determination that, or final agency action that addresses that.
So your position is notwithstanding the fact that this entire proceeding that you're asking us to review is outside the APA, your client is entitled to then come back under the APA to seek judicial review. Can you explain that connection?
Yes, there's the administrative proceeding that is conducted by the agency. That is the appeal process that they spell out in the rule. That is what is accepted from the APA. It doesn't accept it from 6.8. It only accepts it from the process that is spelled out in 569, 571, and the subsequent statutes. It doesn't accept them from rulemaking. It doesn't accept them from any of the other appellate processes that are available to it. So to the extent that we're talking about the agency's final determination being a final agency action, it's lumped in, it's captured by 0.68 paren 1, and we believe that applies.
Even though it's not a final order.
Well, it's a final determination.
Right, but it's not a final order under the APA.
Right, but under the APA, broadly, this court has review of final agency action, not just final orders. There are certain circumstances where it spells that out, but it has review not just of final orders in 6.8 paren 1, but final agency action, and this is certainly final agency action.
What do you consider the action to be?
I consider the action to be the final determination that the department is entitled to not pay my client more than $10 million for meals that they provided. I think the final agency action is the department's determination that they are entitled to terminate them from the program for 7 years, notwithstanding the fact that they didn't find fraud or any of the other requirements that are prerequisite to suspending or terminating somebody for 7 years under their rules.
Well, doesn't that point out a problem in your position that, I mean, it's really not unlike proceedings under 120, 57 and 569 and 57.1, where you have an ALJ that makes determinations, findings of fact, and recommended conclusions of law, and it's a recommended order. Then it goes to the agency, and the agency considers whether then there can be exceptions filed, and so on and so forth. And then ultimately, the agency decides, either the secretary or board, or commission, whatever the entity is that's authorized to act statutorily for the agency on that matter, adopts an order, and that is action by the agency. In this instance, you have an employee within a bureau somewhere in DAX that makes a determination of facts, really, and I guess an estimation of what the law is, and it makes some sort of determination, and it goes nowhere else. And he's not an ALJ, he's not anything else, he's a staffer or something in the agency, and that is the equivalent of agency action or final agency action as envisioned by 12068 that then we're supposed to review?
I think it absolutely is final agency action because that's who the department has delegated that authority to, and under their rules, they say that that hearing officer's word is final. It just says a hearing officer. It doesn't say that the hearing officer has to be a an employee of the department. It just says a hearing officer, whoever they designate. In this instance, they designated somebody who was an employee of theirs. And his word at the end of the day is what would be the agency position.
Sure, but then you're asking the District Court of Appeal to then go back and it goes much deeper than just reviewing agency action here. You're asking this court to review the internal process of a bureau of an agency, and I guess intervening and making redeterminations of things that staffer did.
But that's because the legislature has given them the special authority to set their own appeal process.
Sure, but the question is did the legislature also give us the authority to intervene in that?
I think they absolutely did, because if they didn't, then what they would have done was they would have included 120.68 in the rules that they were accepted from. They did not. All of the APA still applies, and I think you also need to kind of look at the APA as having, in this regard, two parts. There's the process part. That's the part that they're exempted from. But there are substance requirements to the APA that impose obligations on the part of the agency. For example, they have to do rulemaking. They've not been accepted from that. For example, they can't rely on unadopted rules or improperly delegated legislative authority. That would be improper. Those are substantive obligations that the APA imposes on them that they still have to observe. What they were accepted from was their appeals process, not the law that would apply, not their own obligations to go through those processes. And then I'm not sure, the last question dealt with whether the administrative review is governed by the APA. I think I addressed that, but if I've not, please feel free to jump in.
Then why the 20 appendices? Why not a record on appeal, like the regular way, as if it were actually under 120.68?
Well, I raised that issue when the time to file the record came and passed and the agency didn't file one. And what they referenced was the fact that this was a proceeding that was, because their appeal process at the lower level was not subject to the APA, therefore, they didn't have to do the record. I looked, I couldn't find any real guidance on that. In the interest of expediency, we went ahead and we submitted the appendices under the auspices that this was one of those weird ducks that doesn't walk completely in the APA. And to the extent that one could make a colorable argument, I didn't think that it was necessarily the appropriate time to start fighting about that. So we compiled the appendices. We didn't think that would divest this court of any type of jurisdiction to hear the case or decide the case. That would be the record for the court's consideration. Then moving on to the merits.
Well,
Ninjig,
on the merits, just get into the merits for a moment. You spend 2 pages of your brief talking about competent substantial evidence and then a lot of pages talking about a lot of federal regulations and state rules or the non-existence of state rules and regulations. How is it, based on everything you've talked about so far about whether they're under the APA, not under the APA, and now we're back under 120.68 review, maybe, how is it that the hearing officer, I guess your main assertion is that the hearing officer had the authority to make a determination whether the rules were either invalid or that there was an unadopted rule. And it seems like you win or lose on that point. Am I wrong on that?
I don't think you're wrong. But I would characterize it, the hearing officer had the authority to apply the law. The effect of his...
Where does that authority come from?
That comes, he is somebody that is vested by the department with the authority to essentially declare what the law is for the agency.
Isn't he
And
just
that-
making a determination whether your client has a valid claim to funds that the agency is administering?
As it stands under the law, yes.
But what authority exists for the hearing officer to determine whether the law, in this case a rule, is valid or not in the first instance?
Because that goes to what law applies.
Well, but point to me a statutory side, the general law that provides the hearing officer with the authority to look at a rule and say, well, that's a valid rule, that's an invalid rule, it's an unadopted rule.
Well, what I would say is, he is looking at it. 120.57 prevents an agency from relying on rules that are not adopted or relying on rules that are unlawful delegations.
But he's not
of
subject to
authority.
12057.
Again, we go back to the standpoint that there's a process component and then there's a substantive component to what is applied under the APA. The idea that a hearing officer who the department vests with authority can come in and apply whatever law he wants because it's not spelled out anywhere in their rules or in 120.57, even though 120.57 imposes substantive obligations and procedural obligations, that's just not consonant with what the department has invested the hearing officer with authority to do. The hearing officer is articulating the department's legal authority on those issues. So when he makes that determination, the effect of his ruling is not to invalidate the rule for the department. The effect of the ruling is to say, I cannot apply this to this person in this instance because that is all I can do. He doesn't have the authority to declare the rule invalid. It's more a construct of, I just can't use that and rely on that for my ruling.
I don't want to speak for Judge Ray, but I thought I heard her, what I heard Judge Ray asking is, what authority does that officer have to make that to apply a rule, not apply a rule, decide I can't make this determination because this rule is invalid? Where does that authority come from? Isn't his responsibility solely to make findings of fact based on whatever evidence is presented and take the rules as they are and just make a determination? And then you're asking us, I guess that the corollary is, what is our authority to review what that hearing officer did or didn't do and say, yeah, you did that wrong?
I think the authority to articulate what the department's issue or position on the law is certainly something that he has the ability to do. For example, I believe the requirements of 120.57 place a substantive requirement on an agency to not rely on unadopted rules. An agency is prohibited from doing that. It's not just an ALJ, it's an agency. This is the voice of the agency. Their appeal rules vest him with that authority. So when he's making that final determination, he's making the determination that either that's an unadopted rule or it's not, in conformance with the statute. It's certainly possible for an agency to not accept the idea that, every rule they've got is a valid rule. In fact, we cite some in our briefing that indicate that, yes, in fact, some agencies have confessed that their rules are defective.
But doesn't 12056 provide the exclusive avenue for you to make these arguments that you're making now?
Not at all.
How?
There are other provisions in the APA that allow a person whose substantial interests are affected to raise the invalidity of the rule as a defense, which is what we did.
In front of an ALJ, and that is pursuant to 12057 and 12056. So what specific provision says someone that is not an ALJ, someone when you're operating outside the typical 12057 process, you can raise either an invalid rule or an unadopted rule as a defense and have that determined by a non-ALJ, non-12057 hearing officer?
Well, In those instances, the effect of that ruling is going to bind the agency for all parties, as I understand the way the APA applies. In this particular instance, that authority isn't there. But the ALJ, or the hearing officer here, has to follow the law. And if there's a legal obligation on the agency to do something, adopt a rule, and it hasn't done that, then the agency who's making the determination through the hearing officer has to follow the law, has to follow those obligations. And he can either make the conclusion that, yes, this is a law that I can enforce, or he can pass on that and go ahead and say, that's not something that comports with the APA, and I'm going to not enforce it.
Under your reasoning, I mean, what's the point of, proceedings under the APA of a 120.56 rule challenge, or in 120.57 allowing a party to raise a rule invalidity issue as an affirmative defense, if at the end of the day, the ALJ just has to follow the law? And his obligation, of course, would only be to follow rules that were properly implemented.
I think the point of it, allowing it to be raised in the 5-7 proceeding, is really judicial efficiency. The idea that a litigant who's looking to assert that as affirmative defense should not now all of a sudden have to start litigating in multiple forums, which is precisely what many people do. Instead of bringing a separate rule challenge, they will raise it as an affirmative defense, which is what we did here.
Of course, yeah, we clearly have a lot of questions, so we will extend your time, of course, to answer these questions and on rebuttal as well. Did you?
Yeah, a quick question about whether the agreement signed by your client, in which they agreed to comply with all provisions of applicable provisions of the federal regulations, and then with state statute and any rules adopted thereunder, is there a contractual nature to what the hearing officer here is the law that he's applying that fills in any problematic gaps?
I don't think so, and here's why. Because when you look at what the federal regulations require, the federal regulations require payment based upon meals times rate. It doesn't permit them to withhold for improper expenditures, the whole issue of the unapproved days and whether those aren't spelled out in any of the regulations. Those are things that are being imposed based upon the department's own internal processes. So the fact that the contract one wasn't actually the adopted contract that's in the rule, although I don't think the contract was significantly changed in that regard. The notion that the hearing officer was misapplying the federal regulations in terms of justifying the withholding based upon either improper expenditures or the unapproved days, none of those things are really spelled out anywhere in the federal regulations. There are references to certain things, but certainly not the way it's spelled out. So,
there's monitoring and enforcement provisions of the federal regulations, right? I mean, they assume that the states are going to do this.
Correct.
Yeah.
And in that regard, keep in mind also that I would add that during this period, we were operating under pandemic rules. There were all sorts of things that were being suspended by the federal government. Particularly, you're talking about a program where you were providing meals in a brick and mortar setting where you would only be providing a meal on a certain day at a certain time. During the pandemic, that transformed where they were providing meals for 7 days a week for breakfast and lunch all at one time. So the whole process of record keeping for those dramatically changed. But the department through it all never adopted emergency rules that addressed any of those things, never adopted emergency rules that addressed the federal waivers, never did anything like that. Yet those failure to provide, those clerical errors, as the hearing officer described them, meant that my client was out more than $6 million related to clerical errors in how they provided the record keeping.
So is there a part of the provision of rule at any point during this time that would have under which some of the hearing officer's findings, self-dealing, conflict of interest, improper documentation, those kind of things would have been acceptable?
I don't think so, because again, the way the program is structured, you have the payment, the reimbursement, that is exclusively meal times rate. And you've got to prove up that you provided a meal that was a qualifying meal, it met the meal pattern requirements, and you did it at the time, and in this case, because of the waiver, the time and location were flexed. But as long as your meal pattern met those requirements and you could prove that you provided that meal, and nobody's just really disputing that we provided those meals, you're entitled to reimbursement. It's on the other end when you're talking about, did you use the funds appropriately? And in this case, there were allegations of self-dealing. We were looking for places during the pandemic. We were using what we had, particularly to the extent that we were ramping up many activities to meet the need that was out there. In those instances, what you see happening is the proper remedy was for the department, if they felt that those expenditures were improper, to require those to be put back into the account to be used for the program. That's what the rules, the CFR, particularly when it was amended in 2018, but was the practice of the USDA going back to 2008. That's what that required. It didn't permit them to just stop payment. And in this instance, they stopped payment for June, July, and August, and May payment was substantially delayed. And they did it based upon this the idea of unlawful activity. Well, unlawful activity isn't defined. And if all it means is, well, because of clerical errors, we can not only withhold payment but go back and claw back payment, then we just think that's not what is contemplated in the rules. That would be an erroneous reading.
Following on that, you mentioned at the end of your brief, initial brief, some things about due process. So I'm curious, this is kind of like a two-pronged question. The first is, what's the property interest that we're talking about that your client was deprived of without due process? And then the second thing is, if not a proper interest, what is the right that we're talking about here that's at stake? What right does your client have that they've lost? And along those lines, why can't your client just sue in circuit court? If this is a breach of contract kind of issue, you know, it's your client filed a claim, they think they're entitled to the money based on the agreement that they had, they provided a service on behalf of the agency, and they weren't paid for it.
Well, I think because of the nature of the contract with the department, both, I think the contract references this, and certainly their rules reference this, that our remedy is to go through their appeals process, which is what we did. If we were to file in circuit court, what I would expect is we would be met with a motion to dismiss for failure to exhaust administrative remedies. I think going back to the original question, I think the property interest that we have is the fact that we provided these meals in accordance with the federal regulations and are entitled to payment under the federal regulations based upon 229 or 225.9 D7 that specifically provides that the meal calculation that is to be paid and to be paid within 45 days is based upon adequate proof that you provided a meal that met the requirements. And that's where we believe, because that's what we did, that's what we're entitled to. And the due process issues that we see, that the defects in what was provided to us, I think were spelled out in a brief, but that wasn't your question.
Any additional questions? Okay, thank you, counsel. Let's extend appellee's time by 12 minutes, and then that will allow appellants 4 minutes of rebuttal time if you would like to use it.
Good morning. May it please the court. I'm Daniel Norby from Schutz & Bowen on behalf of the Florida Department of Agriculture and Consumer Services. Unless the court would prefer otherwise, I'd like to focus my limited time, or not so limited time, on three issues that preclude any appellate relief here. The first are the jurisdictional concerns that the court has identified. The second are the procedural flaws in the appellant's arguments. And the third is a significant background issue of remedy or redressability that would warrant an affirmance here, even if the Ninja Academy could overcome those first two hurdles. So the first issue, jurisdiction. Of course, as a constitutional matter, this court's power of direct review of administrative action under Article 5 is limited to only those actions as prescribed by general law. The question then is whether any general law authorizes direct review of the hearing officer's final determination here. The only apparent authority identified by the appellant here is 120.68(1), which provides that a party who is adversely affected by final agency action is entitled to judicial review. The term final agency action is not defined in the APA, but agency action is. Agency action is defined in 120.52 to include an order, and the term final order is defined in 120.52 explicitly to mean a final written decision which results from a proceeding under 6 specific statutes in Chapter 120. The statute, 120.52, does not say that a final order includes a written decision from those resulting from those 6 statutes. It says it means written decisions resulting from those specific proceedings under Chapter 120. The substantive law that governs here, 595.404, explicitly requires the Department to adopt and implement an appeal process notwithstanding 120.69 and 120.57. The Department did so by adopting Rule 5P-1.002, and the hearing officer correctly stated in the initial order at page 66 of the appendix that the proceeding below is not governed by the APA. Moreover, a proceeding under Section 120.57 is a de novo proceeding. It's not an appeal. This court said so in one of the first decisions construing the APA, McDonald versus the Department of Banking and Finance. But here, 595.404 and Rule 5P-1.002 explicitly refer to the Department's proceeding here not as a de novo proceeding, but as an appeal. Some research last night has identified at least one decision, it's a non-binding decision from another state, that declined to review the decision of a hearing officer on the basis that the federal regulations here governing the Summer Food Service Program did not envision any state court appellate review. The decision is Mahonging Youngstown Community Action Partnership versus the Ohio State Department of Education. Citation is 2011 Westlaw 6170559. It's a decision from the Ohio Court of Appeals for the 10th District from December 2011. And that court said briefly that the state courts generally do not engraft state procedures of administrative appeals onto a federal program, particularly when the federal program clearly lays out its own procedures for claim disputes and expressly labels its procedures as final. That's the case for the federal regulations here, which provide for a final administrative determination for appeals from the Summer Food Service Program. And it's also true in the very Florida rule that governs here. 5P-1.002 sub 15 provides that the determination made by the Department's hearing officer is the final determination to be afforded to the appellant. Now, the Ohio case suggests that a disappointed party may have some right of review by a federal government official of an adverse state decision. That's certainly not an appeal to this court or the equivalent of this court.
What about just going to our authority under the Florida Constitution? If we obviously have Article 5, Section 4. It provides for what our authority is to review administrative action. And it says, as provided by general law. And we have this one statute, 120.68, that maybe it could have been a little bit better written because it mentions final agency action. And despite there being a number of terms defined, final agency action is not one of them. When we're considering the extent to which we have basically statutory or constitutional authority to review action, how generous should we be when looking at an undefined term in something like 120.68? Should we err on the side of, well, it's close enough, it's roughly agency action, it looks like agency action, and just give them the benefit of the doubt? Or should it be more along the lines of what you've described, where it sounds like, the doubt tie goes to against jurisdiction, basically?
Well, I guess I'd respond in a couple of ways. First, of course, this court's power is derived from the Florida Constitution, and in a number of cases, this court has stated that it construes its own jurisdiction strictly to go no further than what the Constitution authorizes this court to do. In this case, the general law, again, the only apparent one appears to be 120.68. The term final agency action as a phrase is not specifically defined under the APA. But again, the term agency action is defined in Section 120.52. I believe it's a reasonable inference that a final agency action, to add that extra adjective on the front, would be an agency action that is final in nature. So construing agency action along with final order, I think, leads to a reasonable assumption that final agency action, again, if we're not talking about a variance or waiver or some other APA proceeding, would be an order that is defined as a final order under 120.52, and the statute says that it's a written decision resulting from a proceeding under 6 specific provisions of Chapter 120. So I guess that's my answer to your question, is that this court should construe its jurisdiction maybe neither strictly nor loosely, but in accordance with the terms of the Constitution and the statute here, and the statute reasonably construed, we'd contend, supports the idea that there's not a general law authorizing this court's direct review.
Well, we could certainly see how there could be confusion, at least on appellant's part, because the department's own rules, and of course, that's not going to confer jurisdiction, but do provide that the jurisdiction is of our court and the process to invoke that. And I believe this court has actually heard a direct appeal that was filed by the agency on these lunch programs, and jurisdiction wasn't expressly addressed, so I don't think that binds us. But it is an area that I think that is worthy of debate. But my question is, do you see any mechanism for review through complaint for writ of certiorari, because this is an administrative action outside of the APA?
I suppose it's possible that there could be some sort of discretionary writ proceeding or some other procedural mechanism. That is, again, if this court does not accept the view of that Ohio court that I mentioned, that the final determination is the final determination, that there should be no further state court appellate review in accordance with the federal regulations. I agree with the first point that you mentioned, Judge Ray, that whatever the department's administrative rule might say in terms of a right to appellate review, an administrative rule is not a general law that's sufficient to confer jurisdiction on this court. This administrative rule was amended in 2018. Before then, it was not amended. I think the prior time it was amended was back in 1983, when it was a rule of the Florida Department of Education before being transferred to the Department of Agriculture. So it's a rule that has some history. This particular provision, as you said, has not been received any scrutiny from the appellate courts. But I guess that would be my answer to your question.
Is it the position of the agency that, let's assume for a moment that 120.68 doesn't apply, doesn't provide an avenue to obtain judicial review directly, at least from here. Is it the agency's primary position that they don't have anywhere to go to seek judicial relief? If they feel like they got a raw deal, they're out millions of dollars, and they think that this has been contrary to the terms of the deal, so to speak. Is it the agency's position they got nowhere to go in Florida?
That's not our principal position. I think there are a couple of different options. One would be potentially for certiorari, for a proceeding that's not under the APA. The other one would be whether the right of appeal prescribed under these federal regulations is an appeal to a federal government official from an adverse decision from a state agency. So the primary position is not that the decision of the hearing officer is final and unreviewable in any context. I was just providing a couple of different options to this court's direct question. which is whether this is something within this court's power of direct review of administrative action. Our position on that question is that the answer is no, because there is no power of direct review prescribed by general law.
Why couldn't they sue, not as a petition for certiorari in the circuit court or here, but why can't they just sue either for declaratory relief or something else in a circuit court?
Well, imagining a hypothetical lawsuit and what it might say in that context, I think maybe goes to a point.
We
that
provide
Judge-
millions of meals, we're out millions of dollars, and the department owes us.
When we signed a contract where
Yeah.
the understanding was we would be able to get to a court if we were done wrong by the agency.
Certainly, and the terms of that contract, of course, would govern there, and the terms of the contract provide that in the event of a dispute, it would be resolved by this specific process that's outlined here. So if this is reviewed under contract principles, then their right goes no further or no less than what they agreed to in the contract. And the contract prescribes this appeal procedure to the department's hearing officer.
Is it provided, it's exclusive? Are you saying it's a waiver of any right of action in a circuit court?
Judge, I apologize, I don't have a copy of the contract with me to see what those terms say. But if there is some other opportunity for review of the decision, it's not an appeal to this court, is our position on that point.
Because on the flip side, I'm just curious whether Article 1, whether they have an argument under Article 1, Section 21, access to courts, unless it's your position that corporations don't count as persons. I don't.
The access to courts provision obviously is not one that's been raised by the appellant here. They may have an opportunity to access some court, whether it's through certiorari, whether it's through an original new action in a circuit court for declaratory judgment or otherwise. What they don't have is right of direct review in this court.
Right, and the reason it matters, and I understand it goes a little bit beyond what was argued in the briefs, of course, but it's still, I mean, at least I'm just speak for me, still struggling with this interface between this sort of outside the APA kind of determination process. You know, everything, the terminology is different across the board. It's what is it, sort of like a notice of appellate action or something like that, or request for appellate action, and the final thing is not called a final order, it's called a final determination, and it seems like everything about the process is going out of its way to have it feel like it's not under the APA. So there's none of the recognizable, I guess the guidepost or whatever, which is fine. I'm not questioning that. But then when it comes back, so what is this here? And what, presumably, if we say, well, you can't get judicial review here directly, I mean, that certainly there's the question that is raised, well, where would they go, or what should they have done? What should Ninja have done if they have a beef with, probably a bad term here, but if they have an issue with DAX and they think like they're owed some money. I mean, this is a claim. This is not a licensing dispute. It's not a rule challenge, although, I mean, they're trying to make it like a rule challenge, but primarily it's like at the federal level, it's a claim, and DAX administers a bunch of federal funds and so that's
Yeah.
what the question is. And so where would they go if not here? I mean, presumably they should have some access to review. That's what I'm asking.
I understand your question. They can't go here under a power of direct review is my direct answer to that. Whether they have some other right to access either a trial court or this court through some other procedure is something that we don't have a specific position on. It's not the route that they
Let me follow
want.
up on that question, though, because would we have the duty, if we agree with your position that we don't have authority for direct review to, for example, transfer this to the circuit court to allow them, without losing any rights they would have, because we've been litigating this for a while, y'all been litigating this for a while, transfer it to the circuit court so they can file a petition for cert, or convert this proceeding into a petition for cert. I mean, what is our responsibility in that regard?
Well, the court certainly has the authority to construe it as requesting some other remedy. We don't dispute that the court has the authority to do that if it believes it's warranted. I do have two other arguments that I'd like to make that would suggest why, even if there was a jurisdictional forum for them to make these arguments, they wouldn't be entitled to any relief under them, if that's okay with the court.
That's fine.
The first one of what I call the procedural arguments, and as was mentioned in discussion with Appellant's counsel, the thrust of nearly all of the Ninja Academy's arguments before the hearing officer and in their briefing before this court was that the department was applying unadopted rules in administering the summer food service program, and that the rules that had been adopted by the department were invalid because they incorporate by reference the 2018 versions of some of the applicable federal regulations. So for example, their pre-hearing memo at page 13094 of the appendix makes those arguments at length and in their briefing here. Now, it's certainly true that the Florida APA allows a substantially affected person to challenge an agency's existing rules or its unadopted rules. But the procedure for doing that, of course, is a rule challenge. It's not an appeal under Chapter 5P of the Administrative Code. And a rule challenge has to be filed with the Division of Administrative Hearings, has to outline the correct terms in the petition under 120.56 or 120.56.3 or 120.56.4, respectively, for existing and unadopted rule challenges. The Ninja Academy here does not cite a single statutory provision purporting to confer on the department's administrative hearing officer the authority or jurisdiction to entertain a rule challenge or to do something other than assume the validity of the rules that are being applied here. The closest that they come is a citation to section 120.57(1)(e), which prohibits an agency from basing agency action on an unadopted or invalid rule. But the appeals process here, of course, explicitly exempts the department from the requirements of section 120.57.
So when we asked appellant's counsel about that, what I heard was that it's their position that that statute has both a substantive and a procedural component. And the only thing that's been exempted by general law is the procedural part of that, the appeals process part. But there's still the substantive requirement in 120.57 that agencies only follow, adopted valid rules.
Well, there are a number of requirements throughout Chapter 120, but the division between substantive requirements of the Administrative Procedure Act and procedural requirements of the Administrative Procedure Act is something that I just don't see any support for in their briefing or in any of the precedents here. They are exempted from, under 595.40411, the department's appeals process is exempted from those provisions of the APA. The appeals process is to be adopted and implemented notwithstanding sections 120.569 and 120.57. It doesn't say notwithstanding the procedural requirements of those statutes. It says notwithstanding those statutes. And the only statute that has been pointed to as a basis for why the department's hearing officer should not apply an adopted rule is the assertion that it's an invalid or it's an unadopted rule. But that requirement comes from 120.57, a statute that is exempted from the department's appeal process. Now, for reasons that aren't apparent from the documents contained in the appendix here, the Ninja Academy chose not to file a rule challenge at DOA challenging the validity of the department's rules or processes. That is a valid choice. They aren't required to file a rule challenge, but the hearing officer here correctly determined that he had no authority to resolve a rule challenge in the first instance. And of course, this court also does not have the authority to entertain as an original matter here on appeal a rule challenge proceeding. The proper procedure is for a rule challenge to be filed at DOA. That wasn't done here, and the hearing officer correctly determined that he had no authority to do that. Which brings me to kind of the final area that I wanted to discuss with the court, which is remedy or redressability here. If this court determines that it does have jurisdiction, whether it's under power of direct review or some other procedure, and if it further determines that the hearing officer erred by failing to resolve Ninja Academy's rule challenge, there's still an insurmountable issue with the remedy requested by the Ninja Academy here that would make any proceedings on remand or in some other court unnecessary. And that's really a redressability issue, given what they've asked for. The appellant here claims that the department erred by applying federal regulations other than the 2018 versions that had been incorporated by reference in the department's rules. But the Ninja Academy here, in a proceeding below, never attempted to show that it had in fact complied with the 2018 regulations that had been adopted in the department's rules. If it argued that those are the ones that are in effect and the department can't apply anything else, it should have tried to show that it actually complied with those rules. Of course, it's very clear on this record that the Ninja Academy did not comply with those rules. It could never have complied with those rules because the only way it was able to operate at all the way it did was dependent on the pandemic-era waivers issued by USDA, allowing for the grab-and-go meal delivery and the distribution of multiple days of meals on a single distribution day. So if this court had the authority to take up the challenge, and if it had the authority to find that the 2018 rules were the only things that the department could apply, if we went back down on remand to a hearing officer, the hearing officer would ask, presumably, Ninja Academy, did you comply with the 2018 rules? And of course they didn't. They wouldn't even contend that they complied with the 2018 regulations that had been incorporated by reference. The hearing officer noted that these arguments were problematic in conclusion of law number 4. If the Ninja Academy is claiming that Florida doesn't have a valid regulatory program for the summer food service program, why would the consequence be that they're entitled to all of the money they're claiming rather than that they're entitled to none of the money that they're claiming if there's not a validly adopted program in place here? So whether it's on jurisdiction or procedure or under this remedy or addressability ground, there's simply no avenue for the relief that the Ninja Academy has requested this court to provide on appeal.
How does the money flow? I mean, what would, practically speaking, this comes, the federal government does a transfer to the state, I guess, into the trust fund? Is that, and then the DAX administers that trust fund and doles out money to these different sponsors? Is that?
That's right. This is essentially a pass-through program from the federal government with funds administered by the state governments, formerly by the State Department of Education for the last several years by the Florida Department of Agriculture.
Are there any state funds that are mingled with it, or is it wholly pass-through as you describe it?
My understanding is that these are entirely pass-through funds from the federal government, both for the administration of the program and for the actual funds that are paid out to sponsors.
Does that fact also bear on like how we treat it? I mean, that seems like that's really fundamentally a different animal from most administrative proceedings that we get appeals on. I mean, typically under the APA, we've seen them all the time. You've been involved with some of them as opposing counsel. That sounds a little bit different, and it really just sounds like, hey, so the federal government, as a condition for having the state agency administer its funds, as you have to have this some sort of appellate determination kind of thing as a condition for you to get the funds. You're required to put that in the contract, et cetera, et cetera. Does that weigh, I mean, how does that factor into our consideration as to what this is and what we're doing here?
Well, I think it factors into it a couple of ways. One is that was part of the analysis of the Ohio case that I mentioned earlier. The second one is because this is a federal spending clause type of program, the state has an obligation to comply with the federal regulations in its administration of that program. Of course, that's why the department complied with USDA waivers and updated federal regulations throughout its implementation of the program, whether it's conditions attached to spending clause programs, whether it's a supremacy clause issue. There are a lot of reasons why the department is obligated to comply with the terms of its federal program. The other way in which I think this might factor into your decision is that there are similar quirky programs throughout a lot of other agencies of state government. There are fair hearing processes at either DCF or the Agency for Persons with Disabilities, in which the right to appeal from an internal hearing officer goes to the federal district court, for example, rather than to this court or to some other state court forum. So I'd agree with your characterization. This is a little bit of a different animal from your typical Chapter 120 administrative proceeding, a rule challenge, a 12057 hearing that goes to DOA and then back to the agency for this court's review under 12068. But I don't think any of those I don't think that any of those differences in the way this program works from the way a typical 120 hearing works weigh in favor of this court undertaking a thorough and direct review of the appeal. If anything, I think it's to the contrary, that because this is a federal program administered in accordance with federal regulations, that those federal regulations and what they require the state to do in terms of an appeal process for sponsors who believe that they've been wrongfully denied a claim to which they assert that they are due, federal regulations in that process is what should have a primary effect here.
And on the flip side of that, though, so in looking at, was it 7 CFR 225.13, and there's a lot of subsections and sub-provisions in that, but in looking through that and a number of requirements that need to be in this contract or that the sponsor has to agree to, I don't see anything that mentions that they have to waive their right to seek judicial review or that they waive their right to sue in state court or somewhere else. All it does is say you have to have this appellate determination, administrative determination process, and it is the final administrative determination on that subject. If the agency added some sort of waiver provision, or the department added a waiver provision, would that be invalid or contrary to what the federal regs, what would happen in that instance?
So the question is if there is something in the state agencies.
If DACS puts something in their agreement that the federal regs don't require or specify.
I mean, I suppose that could also be something that could be the subject of a rule challenge if there was something in a state rule that was assertedly invalid. That would be a rule challenge to bring at the Division of Administrative Hearings, of course.
Or it could be an affirmative defense, or I guess a response if the department asserted as affirmative defense in a state court suit well, you can't sue us here because you have to go through the administrative process or something which is final. I imagine their response would be, well, you can't make us waive a right to sue in contract.
I mean, I suppose it could be. I mean, of course, parties can provide by contract for resolution of the dispute through some means other than through a suit in circuit court, arbitration, or a binding arbitration, or something to that effect. The hearing officer here, in this particular case, beyond this particular case, the hearing officer chosen by the department has to be someone who's not otherwise involved in the determination, of course, consistent with due process. In this particular circumstance, the department retained the services of a retired administrative law judge, who I think did a very good job on the record here of laying out what the procedures were, what the substantive law was, what evidence could and couldn't be considered by him in rendering his decision. So the mere fact that something may not be susceptible to review by a district court of appeal does not necessarily mean that they have an avenue to sue in some other forum. We're just suggesting that it may not be here.
Well, the reason I guess one reason I ask is, so let's say we dismissed the appeal for lack of jurisdiction. Could Ninja still turn around and at least file suit? I mean, walk me through what that analysis might be. I mean, because it has an implication. The idea, if we dismiss it here and they're basically they got nowhere else to go, and they're just out of luck completely. I think that matters a little bit, maybe.
What remedies they may have, I don't have an answer to your question. Whether this court can provide the remedy they've requested, I hope I've answered to the court's satisfaction, but whether they can or file a state court suit, what causes of action they can bring, I'm not comfortable giving an answer on that.
Sure, but what is we're here talking about what this hearing process is, and they are coming to the department. The department has a responsibility to administer federal funds. They entered into contracts with many sponsors, including Ninja or Ninja Academy. And Ninja Academy, on the sort of this understanding that they were going to get paid, maybe it was a misunderstanding, or maybe they didn't do everything they were expected to do, but they certainly acted in a very big way on behalf of the state in providing all these meals, and they're out a significant amount of money right now, and they've come to the department and said, hey, pay us. We've done, as Mr. Levesque has noted, it's, it's meals times rate. And they've asked us to review what an employee or a retired ALJ or whatever DAX managed to find to do this determination. They're asking us to review that. And I guess the consequence would be if we don't review it, or if we don't review it, that, well, what happens to their claim? And we're just struggling with the idea that if we're going to dismiss them from here, we need to have an eye towards whether they have somewhere else in Florida, in the Florida court system, under under the access to courts provision, to have their dispute resolved. This the hearing in front of the hearing officer is not even, it's not the type of hearing that you would have even in front of an ALJ, which is specified in 12057 in great detail as to what has to happen there. There's none of those guarantees in front of this claims officer, I guess.
So they received the review to which they were entitled under 5P-1.002. And I do want to mention, by focusing on jurisdiction and procedure and redressability, I certainly don't mean to minimize the merits arguments that were made before the hearing officer and then in our briefs here about the reasons why they weren't paid for these funds here. The specific assertions made in this case against them were that they were claiming money for days that had not been properly approved, that they were engaged in self-dealing with some of the leases at these provisions. The Ninja Academy contracted with Grizzly Holding Company, an entity that had common ownership and shared bank accounts with Ninja Academy. So there was a lot of evidence produced in front of the hearing officer suggesting that there was wrongful conduct, unlawful conduct, warranting a denial of the claims here. So by focusing on these higher level issues, I don't mean in any way to suggest that those arguments were not fully justified by competent substantial evidence on the record here. So if there is a review for some action like that, whether it's by certiorari or whether it's in some new proceeding, the department stands behind all of those arguments for why the claims were denied under the controlling federal regulations. Thank you.
Okay, thank you, counsel. If you'll add, please, another 30 seconds, so 4 minutes and 30 seconds for rebuttal time for the appellant's counsel, please.
I will do my best to be brief. First, I want to correct something that I'd said earlier. I think I indicated that the agency could pick anyone, but I believe the rule actually does spell out that it has to be an agency employee for those purposes. But to that end, the department's own rule describes what the hearing officer does as making a final administrative determination. And the hearing officer is tasked with conducting a full review of the information submitted. So while they're using terminology that's not really consistent with what is in the APA, full review would seem to imply that the hearing officer has the ability and the authority to fully look at all the facts, fully look at the law, and make the final determination for the agency. That's the extraordinary authority that the agency does invest in this person who is the hearing officer.
But doesn't the rule almost, not identical, but it does track to a significant degree the federal regulation that specifies what this process is supposed to look like? Do you agree with that?
It does. Certainly the rules that spell out the procedures have been updated since the department, the federal rules have been updated a time or two since the agency adopted theirs. But generally speaking, it certainly tracks the older language, yes.
And so then what is the response that I asked Mr. Norby, doesn't that further indicate that this entire process that we're talking about is outside the APA in like every way? Because the only reason the department has that rule is because the federal regulation requires that they have that rule if they're going to get any of these funds that they're administering. And there's no provision for any of the stuff in the APA. The procedure is different that the federal regs require. So if it's outside the APA because the federal government insists that it be outside the APA, basically to have its own special procedure, why would you then, what's the justification for then coming back into the APA for the remainder of this process?
Well, I think the response there is that the issue is really more what authority the legislature gave the department to engage in the program in the first instance. They gave them the authority to engage in the program, so they've got that authority, but they didn't release them from all of the other obligations that they have. Yes, the legislature carved out a narrow exception for appeal process, but they didn't excuse them from all of the other requirements of state law that would apply to an agency, even an agency that's getting involved with a governing program. They're not federally deputized employees. They are still state employees that are bound to follow state law and can only exercise that authority that the legislature gave them. So where the legislature gave them the authority to accept an appeal process, we're talking about only the appeal process at the agency level. It doesn't affect any of the other remedies or functions of state government that are outside of that process. And one of the things that was mentioned was the issue of whether certiorari may apply, and I believe, if I understood the department's position, that certiorari may apply. Certainly, this court has the authority to construe our notice of appeal as granting it jurisdiction to resolve it or to address it as a certiorari petition, and the authority that we have for that is 537 Southern 2nd 96, the Johnson versus Citizen State Bank case. There's also a first DCA case that came out a little bit differently. It dealt with a timing issue, but they do collect cases where this court has recognized that converting a notice of appeal to a petition for certiorari was appropriate. And that case is Roadrunner Construction versus Department of Financial Services, 33 Southern 3rd 78.
Wouldn't we, I mean, before we get there, wouldn't we have to, how do we get to that point where we could just convert it to cert here as opposed to sending it to the circuit court if the legislature hasn't given us, I know you don't agree with the premise, but just assume for a moment that 12068 didn't apply. So we're in a position where the legislature has not given us authority of direct review by general law. But when then we can come back and circumvent that constitutional provision and say, well, we'll just review it by cert. Typically cert is where you see it, at least from the DCA, it's tied to our jurisdiction in some way. So we're going to have jurisdiction eventually and to review a final order. But this thing is so important, and you're not going to be able to address it completely at the end. So we're going to issue cert and review it now. It sounds like you're suggesting, well, even if it's not under 12068, we can still review all of this just under a slightly different standard. And I understand the standard is much more strict, but it's still, we're talking about the exercise of judicial power to review an executive branch action.
Yes, and going back to some of the questions that you asked me earlier about whether the final determination was really a final order. If it is, then I think 120.68 paren 1 applies. If it's not, then you would have certiorari review under the appellate rules and under the Constitution to conduct that review of a non-final order. That would be my response there. So for the reasons...
Is a circuit court cert or trial court cert review, call it review, whatever, a writ complaint or a petition for cert in the trial court, is that different as a type of review than if it were in the DCA? Like if we transferred it to the trial court and said it's going to be transferred to the trial court and it's going to be a petition, for you to convert it to a petition for cert, would that look differently in the trial court than if it were just kept here?
I'll confess, I've not looked at that distinction. I would think that generally speaking, the type of review that the circuit court would be conducting in that instance is going to be very similar to what this court would be conducting on that type of certiorari review. And to the extent that it's presented in our briefing materials, we believe that the agency grossly overstepped its authority in denying our claims, and we would ask that this court reverse the agency decision and award the compensation that our clients earned during the height of the pandemic. Thank you.
Thank you. Thank you to both counsel for very helpful arguments. The court is now adjourned.
All rise.